Okay, I think I'm going to go ahead and get us started because we have a very, very full agenda today. As I said before, my name is the Reverend Jim Ketchum. I am a retired American Baptist pastor and a lifelong advocate for social justice. We have a great panel assembled today. I'm going to introduce them one by one. And unfortunately, I have to ask all our panelists to keep their presentations to about 3 minutes so we can get through all this. I know all of you are capable of speaking at much greater length. But we'll try to move it along. If you have questions for the participants, if you have questions, you can put them in the chat and we'll deal with those, deal with the questions at the end of all the presentations. So I'd like to start off with Lee Goldberg. Lee is with the congregation Beit Simchat Torah in New York City. And I'd like to invite him to speak to us a little bit about the overall concept of restorative justice and also the clean slate legislation that is currently being worked on.
Okay, great. Jim, thanks so much, and thanks for the to the New York State Council of Churches for hosting this Advocacy Day today. So many of us here come from faith perspectives to talk about criminal justice reform and to advocate for criminal justice reform. Personally, I'm Jewish. I belong to congregation Beit Simchat Torah, as Jim said, and I'm the co-chair of our Ending Mass Incarceration team there. My belief in the importance of criminal justice reform really is informed both by my faith and my own personal experience. We have a limited amount of time to talk today, so I want to talk about Clean Slate specifically. The Clean Slate bill is a bill that provides for automatic sealing of criminal records in a civil context for individuals 3 years following their release from prison for a misdemeanor, or 7 years after their release from prison for a felony. We were really excited to see the inclusion of Clean Slate in the governor's State of the State address this year and subsequently in her executive budget. However, there's a really important difference in the governor's bill that I want to point out. And after I finish speaking, I'll drop a little explainer into the chat that tells some more about it. But the governor's bill would have that 3 or 7 year period, that clock, start ticking after the maximum term that you're sentenced. So even if you're released early for good behavior, for compassionate release, for whatever reason, it is the maximum sentence that you were sentenced to rather than the time that you were released that clock would start ticking. And that's a huge difference in the calculation. And I'm just going to give you a very quick example of this. And again, I'm going to put this into the chat in a second. But for example, if you're sentenced to 5 years of probation for a felony, when you're released, your case is sealed at year 7. If you're sentenced to 5 to 15 years, okay, but paroled after 5 years of incarceration and complete the parole at year 10, again, under the legislature's proposal, your record would still be sealed at year 7. But under the governor's proposal, because the maximum is 15 years in your sentence, you wouldn't be eligible for automatic sealing until year 22. So it's a huge difference, and we believe that while we're, again, very excited for the fact that the governor supports sealing as provided for in the Clean Slate bill, we do think that this time difference is really, really important. The one other change in the governor's bill that I wanted to point out is that employers are unable to consider sealed records under the legislature's version employers are unable to consider sealed records when individuals are applying for jobs. So individuals could sue if an employer, for example, didn't provide you with a job offer because of a sealed record, and you could prove that. Under the governor's version of the bill, there is no enforcement mechanism for that. And that really goes to the importance of Clean Slate in general, that this is a jobs bill. This is an anti-poverty bill. This is saying that once you've served your time in prison, you've served your time, and you are now eligible to rejoin society, to rejoin the workforce, and that we're not going to continue to punish you for the rest of your life and make it practically impossible for you to get a job, for you to get housing, for you to get an education, because every single time you try to do one of those things and try to improve your life, you have to revisit the past and indicate that you have a previous criminal record. That's going to be sealed. And those paper handcuffs that are put on you because of your past criminal record, for which, again, you've already served your time, is going to be removed. And the only time that it will be visible for anyone really is going to be for law enforcement to be able to see those records. So they're not expunged, and that was a change in the law, but they are sealed. And so landlords, employers, educational institutions cannot see whether you have a criminal record in your past, and you don't have to answer, yes, I have a criminal record, once those records are sealed. We think this is an essential bill for racial justice, as I said, an anti-poverty bill, and it really recognizes the redemptive value in all of us. Thanks, Jim.
Thank you, Lee. You're going to be hearing some of these same themes that Lee has brought up throughout this time. If you look at the State Council's ask, you will see a lot of information on background about our theological stance, about our understanding about redemption, about our understanding of avoiding eternal punishment, which is pretty much the system we've got right now. I'd like to move on quickly to Insha Rahman, who is Vice President of Advocacy and Partnerships at the Vera Institute, a great group. Insha, I wondered if you could talk to us briefly about bail reform and raise the age.
Sure. Hi, everybody. Great to see you all, and thank you to the Council of Churches for holding this important event. So, as Jim said, my name is Insha Rahman. I am at the Vera Institute of Justice. But before I came to Vera 6.5 years ago, as a longtime public defender in the Bronx, I've seen the impact of our system of mass arrest, prosecution, incarceration firsthand. And what I can tell from both the research I do, the advocacy I lead, as well as my own experience working in the courts, is the system we have does not actually make us safer. And that comes to what I want to share with you all about bail reform. Bail reform was passed in New York back in 2019 to correct a really fundamental injustice, which is that people horrors of incarceration because they didn't have $1,000 to get out of jail. It disproportionately impacted New Yorkers who are brown, poor, sick, unable to access the wealth and resources that many of us on this call can. And the impact of bail reform now, over 2 years in, has been this. It did two things. One is it decarcerated. There are far fewer people behind bars today across all of New York, especially in upstate New York, where people were being disproportionately incarcerated for level offenses. And so the jail population is fully a third less than it was before we passed bail reform. The second thing it did, though, was actually in public safety. And that's what I want to talk about, because I know all of us are looking at the news each and every day and wondering what is the impact of bail reform on the very real increases in gun violence and homicides across this entire country since the pandemic began 2 years ago. And what we know is this, is anytime that we have looked at the impact of bail reform, people who are released, and over 200,000 New Yorkers have been released after an arrest without having to face the inside of a jail cell as a result of bail reform, only a tiny, tiny portion get rearrested for anything that involves a crime of violence. 98% of those 200,000 people who have benefited from bail reform came back to court, get arrested for any offense that would constitute a new violent crime. So that's really important, I think, for folks to know is bail reform is actually working. It's keeping us safe. We know this, that jail itself actually has what's called a criminogenic effect. And what we mean by criminogenic is it actually results in people having in the future more interaction with the criminal legal system. They get they face the inside of a jail cell again, because the fact of jail is so destabilizing. People lose their jobs, their housing, their connections to communities and families, and all of that is bad in the long term for public safety. So I will end by just saying, you know, we need solutions to the increase in gun violence and homicides that we have seen not only here in New York, but around the rest of the country, including many places that have not done any stripe of criminal justice reform, not bail reform, not parole reform, not releases from prison due to COVID. Many places have actually experienced a far greater uptick in violence than New York. But we do need solutions, and the solutions are community-based. It's investing in community violence intervention. It's investing in the supportive services like housing and treatment and education that keep our communities safe. And I will touch on Raise the Age as well, very briefly, simply to say, in 2018, we passed Raise the Age in this state to actually fall in line with the rest of the country that treats young people like young people and doesn't put them through the adult criminal legal system simply because they are 16, 17, 18 years old. And what we've seen from Raise the Age is it has worked. It has kept our kids back home in their families and in their communities and not, again, facing the inside of a jail cell. Again, whenever sort of, you know, increases in gun violence happen, we look to blame the thing that has changed most recently without actually looking to see, is that in fact driving the increase in gun violence? And again, there's no correlation between Raise the Age and an increase in shootings or homicides. It's just the easiest thing to blame. And so as this legislative session continues, I really hope that our legislature holds firm to hold the line on bail reform, to hold the line on Raise the Age, and actually invest in the solutions, the community-based solutions that keep us safe.
Thank you, Insha. I just wanted to mention one more thing. One of the proposals for reforming bail reform is to allow a judge to try to determine the dangerousness of the person being considered. And this is, I can tell you this, white judges will always find Black defendants more dangerous than white people up on the same charge. It's just guaranteed. You don't have to burn a cross to be affected by implicit bias. So that's.
Can I speak to the dangerousness point? Because I think the average person would say judges aren't allowed to consider whether somebody is dangerous. That just doesn't make a whole lot of sense. But here's what we have seen is, you know, I work on bail and trial justice across the country. And New Jersey back in 2017 implemented a new bail law that actually allowed judges for the first time to consider dangerousness. We've been doing that now for 5 years. The bail population has a lot by 47%, which is terrific, good for them. What we are also seeing though is if people release, about 14% are rearrested for a violent felony while released. In New York, what we have from 2 years after bail reform, that number is 13%. So to the extent that you want to add a dangerousness standard to quote unquote sort of manage arrest better, adding that is not going to make any difference. And we have the data that proves as much. So again, it's the wrong cause that judges aren't allowed to consider dangerousness to actually explain why are we having an increase in violence that is very real, but pointing to the wrong, blaming the wrong problem isn't going to help us find the right solution.
Okay, thanks again, Insha. Next, I would like to turn to Yona Zeitz, who is Advocacy and Communications Manager at the Cattell Center for Equity, Health and Justice. Please talk with us something about the Less is More bill, which was signed back in September.
Yeah, thank you, Chairman. I'm really glad to be here. As was just mentioned, so on September 17th, Governor Hochul signed the Less is More Act into law. And prior to Less is More getting signed into law, New York actually led the nation in terms of reincarcerating people for technical violations of parole. And so the technical violation of parole can be anything like missing an appointment with a parole officer, being late for curfew, failing an alcohol or drug test. And so New York every year sent more people back to jails and prisons who were on parole for these type of technical violations than any other state in the nation. And it cost the state a lot of money, about $600 million annually. And that's just a very, very, very conservative estimate. There was also huge racial disparities in New York City. Black folks were incarcerated for these type of technical violations at 12 times the rate as white folks, and statewide, Black folks were incarcerated at about 5 times the rate of white people. We were really grateful for a lot of folks on this call, including the Council of Churches and some of the other congregations that were very active in the Less is More campaign and helped us, have one of the most broad and intersectional campaigns. And so we were able to get the bill signed into law. And what it really does is it restricts the use of incarceration for technical violations of parole. And what it does is make sure, and we all know this, that, and I think Insha and some other folks have touched on this, but one of the most destabilizing things you can do for an individual, particularly after they've come home from a prison sentence, is to send them back. And what we were seeing time and time again is that, an individual maybe was late for curfew. And instead of the parole officer and the judge, deciding maybe we need to switch to curfew because it's not able for him to get back from his job and home under this time, they would actually send that person back to jail. And that person could wait 60 to 90 days just for a hearing. And so, that means that person was definitely going to lose their job, definitely might have lost the housing that they had. And even if, the alleged violation wasn't even true, they have to get out of jail and start over again. And so we knew time and time again that it was actually being counterintuitive to what parole should be doing, which is supporting people, once they're out and making sure that the last resort is to send them back to jail or prison. And so we're really happy that this is exactly what Less is More did. And it's actually one of the most transformative parole reform bills ever passed at any state level. And it already has led to the release of over 1,000 people. And so we're really excited. So, the main part of the bill is it restricts the use of incarceration. And so for a lot of technical violations, incarceration is just off the table. It's no longer an option. And so it really makes it so the judge and the parole officer actually has to find a solution within the community. And it actually, changes the incentive to actually make the parole system, want to keep people in their community with their families and their jobs. And then the bill does a couple other things. It speeds up the time for the hearings. So folks that are both in the community and incarcerated don't have to wait 90 plus days to get a hearing. So it really speeds up the timeline for that. And then another provision, it also bolsters some due process. And so what happened right now is that if folks got an alleged technical violation, they would be automatically reincarcerated right away. And so, and we're talking about bail, right? And people that are legally innocent. It's the same situation with someone who gets an alleged parole violation. It means that they just have an allegation against themselves. But unlike the bail system or the pretrial system for folks on parole, there was actually no recourse to get out. Once they got that allegation, they could be automatically reincarcerated, and they would just have to wait until they get seen before a judge. And so this creates an opportunity for release, after an allegation. And then the last provision, which we're also super excited about, is our 30 for 30 provision, which actually incentivizes folks to be able to get off parole sooner. And so what that provision does is for every 30 days that folks on parole go without a violation, they actually get 30 days cut off the end of their sentence. And so that will be effective starting in the next couple months. And we also were able to put into the bill, it's actually 2 years retroactive. So people can get up to 2 years of retroactive earned time credits cut off their sentences. And what it really does is it kind of turns the current system on its head. So instead of us automatically incarcerating people for a technical violation, what it does is actually incentivizes folks that haven't violated to actually be able to get off parole sooner. And so most of the provisions of this bill go into effect on March 1st. With some of the remainder provisions, should be done by July. But one thing that the campaign is really focused on right now is making sure that the bill is fully and effectively implemented, because we've heard time and time again that people are still getting violated, that parole officers are telling people on parole that because you have a certain level felony, that this bill doesn't apply for you, which is absolutely false. The provisions of this bill apply to everyone on parole. And so, yeah, so one thing that we're making sure is that, the Department of Corrections and the different state agencies are going to be implementing this bill effectively. And so we'll be doing that work over the next couple months. And yeah, I'll pause there because I know we're getting short on time, but yeah, thanks again for having us. And thank you, Lee, for posting stuff in the chat.
Jim, we can't hear you.
Sorry. I was just mentioning there's a lot of good links being posted in the chat. So please do take a look at that. Because of our time considerations, this will give you a chance to learn more about the particular bills that you're most interested in. I want to turn next to Jeffrey Berman, who is a staff attorney with Legal Aid, and ask Jeffrey to give us just a couple of minutes on treatment, not jail.
Thank you. I'm going to just piggyback off of some of what Insha discussed before I get into the specifics of the Treatment Not Jail Act. But I am a 25-year public defender and mental health attorney with the Legal Aid Society. It's a lie that incarceration makes our community safer. To the contrary, incarceration actually makes people more likely to reoffend. In my practice, I've seen how incredibly traumatizing and destabilizing incarceration is. Too often people languish inside jail with inadequate mental health treatment and medical care while being exposed to violence and rampant drug use. And then they emerge from incarceration into shelters or the streets without stable housing, medical care, mental health treatment in place. And they're expected to procure housing, treatment, jobs, benefits while navigating the adverse collateral consequences of their criminal conviction. And this is a recipe for increased substance use, untreated mental health conditions, and recidivism. And it's really a grotesque revolving door that harms not only these individuals, but our community as a whole. There's misinformation that people with mental illness are more dangerous. Meanwhile, statistics prove that they are 10 times more likely to be the victims rather than the perpetrators of violence. Disinformation abounds that people facing violent charges or who have a prior violent conviction are less likely to succeed in diversion. So we all care about public safety, no matter our race, ethnicity, socioeconomic status, or political affiliation. But to increase safety, we must amend existing judicial diversion to extend opportunities to those with mental health conditions. And no longer buy into fear mongering of us versus them or law-abiding citizens versus criminals. So the Treatment Not Jail Act will expand the drug court statute that was actually passed by Senate Republicans through the budget process in 2009. Currently, a minuscule fraction of nonviolent drug and theft-related charges are eligible for judicial diversion, which is under Criminal Procedure Law 216. However, people with mental health, serious mental health, intellectual or neurocognitive disabilities they're routinely rejected because substance use is not the primary diagnosis. And there's no statute, there's no legal authority for a judge to divert somebody with mental illness in New York State. And this is despite the fact that 1 in 5 New Yorkers have a mental health diagnosis, and roughly half of New York State's carceral population, which is 40,000 people currently, is recommended for mental health treatment. And diversion courts that incorporate evidence-based practices in the field of treatment science are very successful. Currently, there are makeshift mental health courts, ad hoc mental health courts throughout the state of New York that unevenly and apply or minimally apply, that are applied due to a prosecutor's gatekeeping power. There are only 30 mental health courts serving approximately 140 participants in New York, despite, again, there being over 40,000 people who are incarcerated, again, almost half of whom have a mental health diagnosis. Even where there's a connection between the criminal allegation and a person's mental illness, rejection is rampant. Without legislating mental health courts, our judges have zero power to admit a deserving person. So the Treatment Not Jail Act amends Article 216, which is the drug court statute, to apply to anyone with a functional impairment, which is an umbrella term to describe what can include somebody, essentially somebody who has a mental health diagnosis or some other substance dependence or some other type of disability, neurocognitive, intellectual, traumatic brain injury, personality disorders, which are routinely rejected in a drug court. It takes out the charge-based eligibility criteria of Article 216, which is the drug court statute, and makes eligibility centered on need, which is the existence of a functional impairment that contributed to the involvement in the criminal legal system. This person can be treated, and there's a public safety analysis, which is it's in the best interest of the applicant and the public. Treatment Not Jail removes incarceration as a default punishment for non-compliance, expedites processing times for people who are undergoing eligibility screening and awaiting placement, incorporates proven effective harm reduction principles into the statute, encourages the least restrictive and more individualized form of programming during the court mandate, places treatment decisions in the hands of healthcare professionals as opposed to judges, incorporates procedural justice principles. This bill is sponsored by State Senator Jessica Ramos, Assembly Member Ferris Forrest, and we are very, very excited about this legislation. It has gained a ton of momentum. We have a huge coalition, and we are hoping that it will pass in its first year of these amendments being submitted. So that is the Treatment Not Jail Act.
Thank you, Jeffrey. I just want to reiterate that you can find links to these issues and these specific bills, such as the ones Jeffrey just mentioned, in the Ask, which will be posted shortly, I believe, on the council's website. I'm going to move along now to
already
Ronnie.
posted, Jim.
I'm sorry?
It's already posted.
Excellent. Okay. I want to move on now to Ronnie Minter, who is the founder of Sista's Healing Old Wounds and the Freedom Unshackled Coalition. I'd like to ask Ronnie to talk about clemency, please.
Hello, everyone. Good afternoon. First, I'd like to thank the Council of Churches for inviting me to speak here today. And what I'm going to discuss, like you said, is executive clemency in New York State. First, I'd like just to say that this is not a bill. This is not a bill in the Senate or the Assembly. This is an ask of the governor. Executive clemency, as defined by the state constitution, provides the governor the power to grant reprieves, commutations, and pardons after convictions for all offenses except treason and cases of impeachment. So this is solely in the governor's lap. Typically, the governors of this state, especially the former governor and now this governor, have given pardons. Pardons are generally given under executive clemency for individuals who have already served their time, and now they're going to get maybe their record expunged and they're getting pardoned for that crime. We're talking more about the Freedom Unshackled. A lot of other organizations are talking more in regards to time commutations. These are reductions of an incarcerated individual's minimum period of imprisonment. So we would like to see the governors reduce these times, giving person opportunity to go in front of a parole board and present themselves so they can now become taxpayers and become citizens again. Freedom Unshackled has worked extensively with the Prisoners Legal Project, and they have so many applications submitted into the governor's office for clemency, but they get these letters daily asking for legal representation. However, because there's no real process in place and the thousands of applications that are on the governor's desk are not being vetted properly, you may have, just for example, Governor Hochul just gave 10 executive clemencies. She gave 9 pardons and 1 time commutation. So these are the ones that we're talking about. It's the time commutations that we are looking at and saying, you can do more. Freedom Unshackled is asking the governor to do clemencies 4 times a year. Typically, they do clemencies between Christmas and New Year's. That is not a law. That is what they've been doing. This is what we have allowed the governors to get away with. So now we're saying you can do more. You can look at those applications. You can have a real process in place. There's a whole clemency bureau that they can start really vetting these applications and getting people out to try to bring justice to some unjust sentences. So we're saying, let's be racially fair when we do clemencies also. There's been historically more white candidates become eligible for time commutations than Black or brown, and then more men. So we're talking gender also, more men. So we're looking at a racial imbalance and a gender imbalance. And of course, I'm always saying that the women are a forgotten population. So we would like to see more applications for women being processed and looked at and vetted and approved for clemency, and more people of color being looked at, vetted, and approved for clemency. And that's my part on clemency.
Thank you, Ronnie. Thank you very much. Yeah, it's important to remember that this is all in the governor's lap. The governor has very wide powers for clemency, and it would be good to keep up with this issue with her, and make sure that more people get considered in a more timely manner.
And just one more thing, if they want to become involved, you can look for Freedom Unshackled, releasing Asian people in prison, the parole projects. All of us are having rallies and different events that we hold around clemency conversations. So just please plug in and get involved where you can. Thank you.
Yep. I'd like to turn to talking about re-entry of incarcerated persons and the jails to jobs program that the governor has proposed. I'm going to ask Elder Chibuzi Okori to speak to us on that. Chibuzi, are you there?
Yes, I'm here. I'm here.
There you are.
Yes, how you doing? Hi, everybody.
All right.
My name is Chibuzi. I'm from the Church of Gethsemane. I am
Chibuzi, excuse me, your video is off.
Okay.
Yep.
Okay, can see me now.
There you are.
Thank you. My name is Chibuzi Okori. I'm from the Church of Gethsemane. I work with those in prison. The Church of Gethsemane was founded for those who are in prison and those who have already been released. We visit those in prison and assist them with their needs. Some incarcerated persons came to become part of the church while incarcerated, and they have a place of belonging, while in prison. And when they return home, they become part of the church. We believe that people can change, and the re-entry group of the church was composed of formerly incarcerated men and women who meet twice every month to discuss the issue relating to parole, job, treatment, and housing. Formerly incarcerated persons provide a tremendous support for each other, in terms of job and housing, where they relate the news. Anyone who got employed, they will ask their boss to please employ my friend who has a record, and from there we spread the news of employment. Again, family members are key sources to their transition process. When a member of a family is in prison, the whole family is equally incarcerated. So our part of advocacy is to contact the state legislators and to help change the laws that will help elderly parole, and also to implement the measures to help create a conducive prison environment and educate the public on how to create job and affordable housing for those who have already been released. And they have to understand again that it's not coming home from prison, it's not the end of it. So being on parole is another hell. I'm sorry to use that word, another hell on earth outside here. So we try to work with everybody, and in as much of helping them to heal, the wounds of incarceration. A lot of people are wounded, And right now we are working with other groups out there, to contact the legislators, also advocating to pass the fair and the timely parole and also elderly parole bills, and to help those who have spent a lot of time in prison come back home. It is time to hold our legislators to their commitment, most of them to encourage them to co-sponsor these bills. And we are demanding their support into elderly parole that will allow incarcerated people aged 55 and older who have already served their time to be considered for parole release. And this will also help the taxpayers to save money. And this will also help us to reunite these people, our brothers and sisters in prison, with their family members. And this will also help them to become law-abiding citizens and also pay their taxes. So the Church of Gethsemane has been doing this and helping our friends and family members and brothers and sisters in prison to return back home after they do their time. Also, if we can do this together, I think we are equally touching bases, through justice. Our justice system is not doing much, to reform our prison system.
Thank you, Chibuzi. One of the best ways to help people come back from prison and land a job is helping to get them educated while they're in prison. We used to have the tuition aid program that included prisoners. They've been dropped from that list. I'd like Carol Eady to talk about that. She's the co-chair of Women on the Rise, telling her story or worth. And she's also a director on the board of the Center for Community Alternatives and coordinator for Exodus Prison Project at Abyssinian Baptist Church. You're busy, Carol.
Yeah, I am. Hi, how are you?
I'm doing well.
I'm sorry, can you tell me exactly what you want me to focus on?
Yeah, sorry. I was asking you to focus on the tuition assistance program, restoring it for prisoners.
Yes, that's what we're waiting on Governor Hochul to sign next. We are, I am a product of the TAP program after being incarcerated, and I started there and I came out, excuse me, and continued my education with TAP and FAFSA, what I used to call BEOG, at John Jay College of Criminal Justice. And I ended up getting my bachelor's and my master's within a 6-year period, and ended up teaching at the school. So I would like to say, I know you see it in the news consistently, excuse me, that the more we allow people who have been, excuse me, who have been incarcerated, and mostly due to systemic issues, like not being able to get a job, like not having fair housing, like not having access to good medical care, the more we allow them to get an education when they're incarcerated, the least amount of recidivism we have, because we've changed the focus while their head is clear, while they're able to think, while they're on their meds, and they're able to change and decide to get the help that they need, that they may have not been able to keep up with in the street because they were unstable. You can't get up and go to work every day if you're homeless. You just can't do it. You have to be able to wash. You have to be able to get to sleep. You have to be able to get up on time. You can't do that in the street if you don't have a place to live. You can't get up, you can't go to work every day if you're mentally ill and you're not taking medications, or you're not in therapy or seeing a psychiatrist some way to keep your mind stable. It just can't be done. I can tell you that those were all my issues. I was addicted to drugs, I was depressed, I had PTSD, and I was homeless. I had all the dreams in the world. I remember even being in a shelter once and trying to start school, but it just didn't work because it was just too busy there. Women doing some of everything else. When I got to jail and my head quieted and the addiction, the need to use was lifted, I thought about my family and my children, and I was ready. And when they gave me the opportunity to go take some classes, I did not want to stop that when I came home, and I immediately enrolled in college, and I just kept going. And I got a job with the city where after I completed at the same time I was going to school in the evenings, and I took a vocational course in the daytime with the Department of Children's Services and learned how to use the computer because I had been using for 12 years, didn't know anything about it, had almost forgotten how to type. I graduated the 6-month program and got a temporary job with the city of New York. That was in 2000. Today, I have 21 years with the city. It just doesn't make sense that we keep wasting money on locking people up and denying them education when we could put them in alternative to incarceration programs and still let them have access to education and healthcare and housing. Even if it's like, I went to college, my first 2 years of college, I was in the shelter, but my focus was gained by the fact that I was stable, you know? And so that's all I can say. I mean, it doesn't get any, you know, I'm just grateful. I'm still working with the program that helped me get into all those programs, into college and into the vocational program. I'm still working. I'm on the board of the Center for Community Alternatives because it was their Crossroads program. I still work with them 22, 23 years later. I'm still with them because I'm so grateful that they helped me to get to continue my education after I started while I was incarcerated.
Thank you, Carol. I really appreciate your efforts to pay back to the community and stay involved, help other people in similar situations. That's
Yes.
just excellent.
you.
I'd
Thank
like
you.
to
Thank you for
finish up
having me.
now. I'm sorry.
Thank you for having me.
You're welcome. Yep. Keeping in mind, we're down to about 17 minutes left, and I want to have time for a few more questions at the end. We're going to end up with Anthony Dixon talking about fair and timely parole and elderly parole. He's the Director of Community Engagement for the Parole Preparation Project.
Hi, everyone. Happy to be here. And I feel so at home with so many different advocates and organizers and charming group of fellas. I work in a space that deals with mass incarceration on the back end, namely elderly people that have also been sentenced at the front door to excessive sentences. These are the individuals that pose the least risk if released, but are the most individuals that are denied parole. And I want to categorize that as something a little bit different than what we are used to. In the last 20 years, there has been some incremental, significant decrease in New York State prison population. But at the same time, there has been a sweltering of the gaps, so to say, that elderly people have in fact increased the prison population. So currently there is 1 out of every 2 individuals in New York State prison serving a life sentence. By comparison, that is the 2nd largest prison population of lifers in the country. And these individuals are now languishing in prison. Just recently, there was a report released and a few months ago by the Columbia University that stated that there's more people dying in New York City. The vast majority of them are elderly people every 2 days. The average mortality rate in New York State prison varies between 57 to 59. Every 2 days on average, someone is dying in prison. And again, the majority of them are elderly people who no longer pose a threat to society and are the best equipped because they've been in prison for so long to, in fact, contribute to our communities. to let them out when they're in their 60s and 70s is in fact against what correction was supposed to do, equip them where they could be an asset to our community rather than a liability on resources in our community.
Thank you very much, Anthony.
We work with this population with the RAP organization, our sister organization, and trying to bring about 2 bills. One is the Elderly Parole Act, and also the Fair and Timely Bill. 2 bills that I'm sure that most people in this audience are aware about, and perhaps we'll talk about it further later on. Thank you.
Thank you. Yeah, again, many of these, the bill names and numbers and the sponsors are listed in the back of the ask. We help you get a little deeper in the woods there after we get the theology and theory out of the way. But do please take a look at that at the New York State Council's website. Also, we will try to provide some of the resources that have been put into the chat, so people have all those links, whichever ones are not already on the council's ask. So I really appreciate everybody's contribution. Does anyone have questions that haven't already been answered?
I have a question about
Yes.
Clean Slate. This is Ravi. Is this a civil procedure we're talking about? Lee already said it doesn't come off the federal databases or criminal records, but is it retroactive? And the reason I'm asking this is about the impact it will have on immigrant communities, which if there's a record, it can be used against them. So I'm just trying to find out what the extent of the Clean Slate would have on an immigrant population. Thank you.
So that's a great question, Ravi. I'm actually not sure the answer as to whether the law enforcement provisions extend to immigration authorities, but I can look into that and get back to you.
Yes, I would appreciate that, and also the retroactivity, because immigration is retroactive. So if you can make it retroactive, that could have a huge impact on people's cases. Thank you.
In terms of whether the waiting period has already expired, like, for example, if you've been out of prison for 10 years, so the 7-year waiting period would have expired. Are you asking whether it applies to someone in that circumstance?
Correct.
Okay, I don't know the answer to that either, and I'll look into it.
Okay,
Thank you.
thanks. Bob Elmendorf, you've had your hand up.
Yeah, I had a comment. I think I sent it to Jeffrey on the chat, but things are going so fast. It's a wonderful program. You guys are doing a great job. I appreciate all the speakers. I toured Batavia federal immigration prison maybe 10, 15 years ago. We were working with the Ansar Mahmoud case. You probably heard about that. You guys, anybody around Rochester heard about it. And Rochester Democrat Chronicle. So we got the warden to tour it because one of the women on our committee met with ICE, got us a meeting with ICE in Buffalo. And then the ICE guy, he's in charge, he's over the warden. And so I said, oh, look, I said, we like to tour the prison. He says, okay, he says, and because the Ansar is there, we know you can't see him because of the glass, but so I said, here's who's we're bringing in to the tour. And I named a bunch of people to bring in, right? And I'll tell you something. If you haven't been inside that prison, you have no idea what's going on in federal prisons. And I had no idea. They have courts in the prison. You talked about mental health courts. You know where all the courts are? They're in the federal prisons. They got the money. So what happens is they scoop the guy up, wherever he is, from whatever South American country he tried to come in, okay? He comes into our country, they scoop him up. Then they put him in a holding tank. in the prison. He's got the orange jumpsuit on. There was one guy there, he was bigger than I was. He was 6'6". And by then we're so ticked off, we're touring the prison. We started waving to everybody, you know, we just about had it, you know. And he waves back like that, but he's behind this big glass enclosure. He's right next to the solitary confinement cells. They got 7 or 8 solitary confinement cells right in the prison. You got 37% of the guys that are in the prison, and it was all guys in this prison, 37% are on psychiatric medicines, okay? They allow no contact visits, so they have no contraband in there, and they sweep the cars underneath with mirrors, the federal, okay? But who brings the contraband in, of course? It's the guys that work there, right?
Yeah.
Okay, so anyway, not only do they have the courts there, they have the clerks, they have secretaries, they have everything. It's an entire bureaucracy inside the prison. So they process the man who is in there right through, all the way through the prison. Then he's held, his court comes up, and then they got planes and everything. They fly him right the heck out of there back where he was again. I mean, it's similar to the federal transfer station out in the Midwest and everything. I work with a lot of federal inmates, Muslims, over the years. But so I don't know if you guys know that, so I'm going to stop talking.
Yeah.
All right. Thank you, Bob. Anyone else have questions? We have 7 minutes left. I think we're all kind of in shell shock covering all those issues with all those different speakers. It's a lot to take in.
Can I just say on the general front, I mean, I think that there's a lot of push from some to try to repeal parts of bail reform, to introduce an interest standard, to slam less is more, to blame raise the age. It's really an effective political ploy that's getting used. I was just curious if anyone here has thoughts about how best to push back on that narrative.
I think it's best to push back. And I'm just going to say, just this morning, there was a topic put on social media by the sheriff of Albany, and just out of nowhere, they started talking about this is a direct result of bail reform. And the pushback comes from each one of us when we see something like this, pointing it out and saying, this topic has absolutely nothing to do with bail reform, but this is what they're doing. They're taking every conversation that they can. We could be talking about apples and they'll say it's because of bail reform. He was talking about an incident that happened inside of the facility, the correctional facility, and a guy tried to tie it into bail reform. Clearly, this isn't bail reform because they're in the facility. So, I mean, it's just the narrative that's being pushed and the way the media and everyone is picking up on it, and our voices aren't getting heard. So I say, when you see it, combat it. That's just how I deal with it. But I also want to thank everybody who spoke on here, because every issue that's on here is in fact a way to correct extreme sentencing, racial profiling, really. And it's a way to combat it all. Every one of these bills and issues that was spoken to today can right the wrongs of the criminal justice system.
Absolutely. And I would encourage people not to discount the power of a letter to the editor, not to discount the power of going to meet someone, a politician who you know has been using fear and blaming things on bail reform. They don't always hear from a lot of people, but they know they can get votes by scaring the white suburbanites. And having 5 people send them a letter is like an outpouring of information. It will be hard to use rationality and statistics to deal with the fear dynamic that they've put up, but I really encourage you, write those letters, explain the difference, confront people who are talking this kind of nonsense, and let them know what the facts are.
Yeah, Jim, I just put in the chat, there's a great website that echoing what Ronnie just said, where you can report instances of misinformation like this, and this is by the organization Forward US. They will produce rebuttals to these stories that are providing misinformation. When you see a New York Post story, for example, that ties something to bail reform that has no connection to bail whatsoever, send it into this website. You just have to provide a link. It's very easy. It's justicenotfear.org/new-york. And that's a way that you can do some real citizen journalism and get your voice heard.
Anthony? Go ahead, Yona.
No, yeah, another thing I would add, just on top of Lee's point, if you see, your local sheriff or, you see stories in your local newspapers where it's clearly fear mongering, misinformation, and kind of distortion of what bail's doing, folks can also write letters to the editor, and you can really just lay out that, this story is actually inaccurate, and time and time again, the data has shown that bail reform actually is not a correlation to, rise in violent crimes, and make it clear. And, that really does make a difference, because as what we said is, the elected officials, they read these newspapers in their jurisdictions to kind of get a gauge on what people are saying and hearing. And so, if they see people writing letters to the editor rebuking what the sheriff or what the other folks are saying, it really does make a difference. So I just wanted to name that as well.
All right.
Yes, Anthony, do you have something you wanted to add here? I see you.
You talking to me, Peter? Would you?
Oh.
I think she had her hand up before.
Oh,
I
good.
was
Yeah,
gonna
yeah,
say
yeah.
something.
Oh, yes, she did.
Sorry.
You guys familiar with that case where the inmate was thrown downstairs to the New York State prison?
Yeah. Bob,
And,
I'm going to ask, can you hold this back? As Sumati was waiting to ask a different
I'm
question.
so sorry. I didn't know that. Yep.
That's all right.
Right here, those of us who live in New York City, this question of public safety versus criminal justice reform is very much a part of the discussion of the agenda of both the mayor and the Alvin Bragg, the attorney general. What is his role? I think it's Alvin Bragg.
The district attorney.
Yeah, the district.
Prosecuting.
That's right. Yeah, and so, I wondered if anything was being done to meet with them, with the mayor and with Alvin Bragg, the district attorney, New York City district attorney, because I think I think that my sense is that public safety played a big role in the mayoral election.
Yeah.
Very big.
Sumati, I'm sorry to interrupt you. We have 20 seconds left. We're all going to be ripped out of this room shortly. But I would just say, we are the ones we're waiting for. If you want to know who's talking to the mayor, make an appointment with the mayor. And I'd say that to all of you. So thank you all again for your time and your presentations.